Hey everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here in this video. Okay. Oh my god, I'm so tired. It's like, oh, it is the song that never ends. So, you know how I tell you guys I be pulling documents left and right, and then I just be so overwhelmed with everything else that I never get back to doing the videos. So, the Minnesota case. Several people posted on videos that I did a few months ago where they talked about the Minnesota case against Mr. Kelly had been dropped. So, of course, I went to see if it had been dropped. So, Minnesota, or Hennepin County, is in the process of switching over to a new system. So, they have two systems out there. So I looked in the original, the legacy sentence. I couldn't find anything about Mr. Kelly and this lawsuit that the state attorney came out, back in 2019 and said he was charging Mr. Kelly with assaulting this person that he met at a concert, or to give her free tickets to the concert because she couldn't get into the concert because she was underage. And so he invited her back to the hotel room. I guess they got busy, and now, 30 years later, she talked about she was assaulted. Okay, I couldn't find the case. I couldn't find the original case. I couldn't find where the case was closed. There was just like no record of these charges being filed against him. So I went to the new system. Couldn't find any criminal case in the new system. So I kept saying I was going to call to see if somebody in the clerk's office could give me some information. But, life happened and I forgot about it. So, back in April, while I was looking through the legacy system and the new system, I did come across where a civil lawsuit was being filed against him by this person in Minnesota, and that she had filed this lawsuit back in February. And so there were like a whole bunch of documents that I had to download. And of course, I told myself, I am not getting ready to spend a whole day going through these documents. And so it got put to the back burner and I kind of forgot about it. So today, Jennifer Bongine had made this post. And in the post, she stated that she's not licensed to practice law in Minnesota, but they were working to find attorneys in Minnesota that could take on this case. And so I clicked on the post to see what was the original post that she was responding to. And so the original post was from somebody who was upset that this person in Minnesota was trying to get a default judgment against Mr. Kelly for not responding to their request. Now, I don't know how all these people are suing this man, and he is incarcerated, has lost everything, and these judges are entering these default judgments. So then I learned that the plaintiff in the case had withdrawn their motion for a default judgment. And then someone posted on IG, I believe it was, where someone had written in for Mr. Kelly and was saying that this is the first they are hearing about this case, that they haven't received anything in Chicago or Brooklyn about this case until now. And so they wanted the judge not to rule in this default. Just crazy. And so, people are upset. Why is he defending himself? This isn't fair. Why are these people allowed to go forward with these lawsuits when this man obviously cannot defend himself? And I just feel like there should be a law against this, because at this point anybody can go and file a lawsuit. So we know the Heather Williams' chick has already been awarded $4 million while he was incarcerated, didn't have proper attorneys or effective counsel, and they're just ruling and just handing out this man money like it's monopoly money, which I guess theoretically it is monopoly money because he don't really have it. But anyway, then they ruled that the Midwest funding people who owned the building where his studio was, awarded these people $4 million when their original lawsuit was for $300,000, and they were basically trying to collect back rent, which was like $175,000, and then the rest of the money was going to restore the building so that they could rent it out. But they were awarded $4 million when they weren't even when their damages was nowhere near $4 million. But then the judge just said, okay, well, he ain't here to defend himself, so we're going to give you $4 million. Now here this person come trying to get this $4 million. So, like I said, there are a lot of documents. I am going to read I'm not going to read all the documents because a lot of it was just, affidavits swearing that they had notified him at the MCC. Actually, I'll just go through them and basically tell you what they are. This one was an affidavit for someone named Sammy Nachgal, being first duly sworn, deposed, and state the following: I am the attorney for plaintiff in the above captioned matter. I submit this affidavit in connection with plaintiff's memorandum in support of proceeding under a pseudonym. And then, so she doesn't want to give her name. And then, this was funny. So she doesn't want to give her name and she wants to go under a pseudonym. And then she's providing evidence as to why she wants to go under a pseudonym. And she says that he was charged with misconduct in Minnesota. And then they have a YouTube video from CBS New York talking about he faces new sex crime charges in Minnesota. And then another YouTube video where it was about him being charged with prostitution in Minnesota. And so they were going on and on about these different news outlets that were posting these news stories. And so they talk about the 3 individuals that were arrested for separate schemes of harassment, threatened, intimidation. And we know that was Richard Arline, the guy Michael Williams, and then Don Russell. So they're introducing all of this into the case as justification for her to be able to remain anonymous in her lawsuit. And then here was another one from the Richard student guy, first duly sworn, deposed, and state as follows: I am the attorney for the plaintiff. I submit this affidavit in connection with plaintiff's application for a default judgment. To date, defendant Robert Sylvester Kelly has failed to plead to otherwise defend in this action. Of course he hasn't, because he has more important things to deal with. And this was from February of this year. And it says, attached hereto as Exhibit A is a true and correct copy of the document generated in connection with my November 30th, 2021 search conducted pursuant to the Service Members Civil Relief Act of the database available concerning defendant's military status. Well, he ain't in the military. For attached hereto as Exhibit B is a true and correct copy of the report of Dr. Alfred Kara Yusuf, MD, regarding his October 28, 2018 psychological consultation with the plaintiff that plaintiff and my office obtained from the Social Security Administration. Affidavit hereto as Exhibit C, not that whole girl out here trying to get some SSI payments because she can't keep a job and trying to claim that she damn crazy. Lord, what people would do not to work. So then there was a sheriff's affidavit showing where they served him a copy. 71 Van Buren, is that where the MCC is? And that was February 19th, 2021. And then another affidavit of service for April 5th, 2021. Oops. And then another one for June 16th, 2021. Oops, I didn't mean to open that. June 28th, 2021. Wait, hold on, guys, because I didn't mean to open the document. Okay, so looks like then she filed another one on July 22nd, one on July 26th, one on September 8th, October 27th, January 4th of this year, March 30th of this year. So this is all the times that she has tried to serve him, and I guess he didn't respond. And then here is a cover sheet. Information is not known. Filing party at the time. So this is basically, let's see, the attorney. Plaintiff alleges that defendant assaulted her on July 11, 2001 in Minneapolis. So this is like her initial paperwork. Plaintiff alleges she sustained serious and permanent psychological injuries as a result and seeks monetary damages and other relief set forth in the complaint. The date of the complaint was February 23rd, 2021. Estimated discovery completion within to be determined. And so this was just the initial cover letter. Now, let's see. Then we have, so then she had multiple complaints where she amended the complaint. So she has one from March 10th, June 28th, September 7th. So she just can't even get her story straight. So basically, plaintiff brings this action for money damages arising out defendant's assault of her when she was a minor. Plaintiff Jane Doe is a Minnesota resident. Upon information and belief, defendant Robert Sylvester Kelly is an Illinois resident. The court has jurisdiction over plaintiff's claim and venue is appropriate pursuant to Minnesota Statute 45209 as the events alleged herein occurred in Hennepin County. Oh, come on. Facts. On July 11, 2021, Jane Doe encountered defendant at a city center in downtown Minneapolis, Minnesota, where he was signing autographs for fans. Jane Doe handed a piece of paper to defendant for him to autograph, and defendant returned the paper with his autograph and a phone number on it. Later, Jane Doe called the phone number and was directed by defendant and or an accomplice of defendant to a hotel in downtown Minneapolis to meet the defendant. When Jane Doe arrived at the hotel, she was met by an accomplice of defendant in the lobby who escorted her to defendant's hotel room. Jane Doe waited in the hotel room a short period of time before defendant entered. Defendant gave Jane Doe $200 to dance naked for him. Defendant removed Jane Doe's clothes and his own and laid on the bed. Jane Doe climbed on top of defendant and danced for him as he rubbed his hands all over her body, including her vaginal area and breastises. At the time of the incident, Jane Doe was 17. Upon information and belief, defendant was aware that Jane Doe was 17 at the time of the incident. At some point during the incident, defendant told Jane Doe that he would put her name on the guest list for defendant's concert that night, which would allow her to get into the 18 and over concert even though she was not 18. As a result of defendant's assault of Jane Doe has sustained permanent debilitating psychological injuries. Jane Doe has received SSI disability benefits as a result, and she needs to go to jail for that. As a result of her injuries since she was 19 years old, so this heifer ain't worked a day in her life. Jane Doe has also received and continues to receive medical treatment for her injuries. Ooh, these people going to hell. Whew. As a result of defendant's actions, Jane Doe has sustained and will continue to sustain general damages, including but not limited to psychological trauma and disability, emotional distress, and pain and suffering in amounts to be determined at trial and reasonably believed to be in excess of $50,000. As a result of defendant's actions, plaintiff has also sustained special damages in amounts to be determined for past and future medical and other treatment expenses, lost income. What lost income? She's been on SSI since she was 18 or 19 years old. Oh, Lord. Plaintiff incorporates the foregoing paragraphs as it sets forth fully herein. Defendant engaged in touching a plaintiff on July 11, 2001. Plaintiff did not consent to sexual contact. Sound like she did to me. Plaintiff could not legally consent to the contact. And she couldn't legally go to that concert, but she had her behind down there. Anyway, defendant used force or coercion to make the sexual contact. No, it seemed like he asked her and she obliged. Plaintiff was 17 years old at the time of the contact. Did she tell him that? Did he ask her how old she was? I'm confused. Defendant was 27 years old at the time of the contact. Defendant was in a position of authority over plaintiff at the time of the contact. Really? Plaintiff sustained and will continue to sustain damages alleged herein as a direct result of defendant's conduct. As such, plaintiff is entitled to money judgment, child. Money cures it all, y'all. I don't care how crazy you is, how debilitated you is, whatever is going on, write a check and I'm going to feel a whole lot better. It's basically what these heifers' philosophy is. Whew, child. Anyway, action for damages pursuant to Minnesota statute 541.073. Plaintiff incorporates the foregoing paragraphs as if set forth fully herein. Defendant's conduct as alleged herein constitutes abuse as defined in Minnesota statute 609.342-609.3451. Plaintiff sustained and will continue to sustain damages alleged herein as a direct result of defendant's abuse. As such, plaintiff is entitled to a money judgment against defendant in the amount determined at trial and reasonably believed to be in excess of $50,000. Jury demand. Plaintiff requests a trial by jury on each count set forth in the complaint and on any additional or amended counts which may hereinafter be alleged. So she's going to make up some more stuff as we go along. Wherefore, plaintiff respectfully requests the court grant the following relief. Leave of court to maintain this action pursuant to Rule 10.01 to proceed anonymously and identify plaintiff only by the pseudonym Jane Doe in all filed or saved pleadings, motions, and other documents in this action, except as otherwise stipulated by the parties or ordered by the court. Findings that defendant liable of plaintiff on the counts alleged against him. A money judgment against defendant as and for compensatory relief for plaintiff's special and general damages in an amount to be proven at trial and reasonably believed to be in excess of $50,000 and awarded against defendant for costs of reimbursements incurred plaintiff in bringing this action, pre-judgment, post-judgment, and post-verdict interest. Leave to amend the complaint to seek punitive damages and any further and additional relief the court may deem just and equitable. Child, and like I said, she went and amended this thing the same day. And then she amended it again on June 28th. I'm thinking she just changed the wording. I'm not going to read through all these differences because they're the same number of pages. So she may have changed a couple of words here and there. And then again on September 7th of last year. But it seems like it's pretty much the same thing. I'm sure she just changed some words or something, corrected spelling, some other foolishness. Okay, child. So then on July 22nd of last year, and then February 14th of this year, and February 14th of this year, she submitted some documents, and it says, what is this? Cover sheet provides a record of non-public documents in the court file. So she was trying to file something. Let me see what box she got checked on this document. Okay, so she checked. This is a court order authorizing me to file these documents under seal or as confident. The order was written July 21st, so she filed something, child. I guess the court asked her for something. She filed it confidentially. And then the one on February 14th, it says they are medical records as defined in public access. So I think this is what she was talking about. She went to the psychiatrist. Let's see, and then let's see what this one says. God dang it, I didn't mean to open it. I want to open all this stuff. Okay, the documents are non-public for another reason. It says required, lists the specific legal reason why the documents are non-public. And she says this document contains identifying information of plaintiff, which the court has previously ordered may be filed confidentially. So she then filed some other nonsense. Okay, let's see. Listen, I don't want to open all these documents. I'm trying to read this in the preview pane, Adobe. Okay, let's see. So then we got a memorandum from April 5th, 2021. And so this is where I guess she actually wrote out her complaint. And then they include the statutes, factual and procedural background, where she's basically stating the law that allows her to file this lawsuit. What did she say? As evidenced by, then she talks about social media. So it says, defendant, a well-known R&B artist, received considerable media attention following the announcement of criminal charges against him in Minnesota. As evidenced by social media and other online content, defendant apparently has numerous fervent defenders. After news broke about the Hennepin County criminal charges, many individuals began leaving hateful and harassing comments about plaintiff under news video clips reporting on the criminal charges. See affidavit of Sammy Nechigal, Exhibit A. Some commenters call plaintiff greedy, a liar, and fame-seeking. This is disgusting at this point. From this announcement that was made, I would be trying to track down the alleged phone number and the hotel records to prove any kind of validity to this victim's accusations. This news allegation supposedly happened 18 years ago. This is beyond ridiculous at this point. At this rate, any woman in any state can accuse him of something and say it happened decades ago. Honesty is the real victim. Honesty is the real victim. It is being abused. It's non-essential at this point. Women and greed are making names for themselves at the expense of this man. And then another comment said she danced and got paid. Get the fuck out of here. She was mad because he changed his number 18 freaking years ago. WTF. And then another comment, R. Kelly innocent. What's wrong? She can't afford her hotels either. Everybody want money and fame. I tell you, haters don't have a lie. You haters don't have a life. I'm sorry. Then another comment was a flood of lies. And then they cite where, this stuff came from, NPR, an article on NPR, an article on Variety. So it was like, websites that carried the story, and then they allowed people to leave comments. Then it goes on to say many commenters degraded and shamed plaintiff and call her a prostitute. Basically, I would like to know, how can y'all charge this man and he was acquitted? This woman was a prostitute, accept payment. She should be in jail as well. No reason for this man to be in jail by yourself with this woman accept it, and she probably been a prostitute forever and a day, regardless of her lying. Oh wait, guys, hold on, my battery is about to die. Okay, let me see where I left off. Let's see. Say probably been a prostitute forever and a day, regardless of her lying for her by her. And I think I just do that. How was she? Oh my gosh, she was already a prostitute. I'm willing to bet she was prostitution. She knew, Lord have mercy, better. She lied about her age. She should have never even, if that was even some sushi, would have, what in the world? Long time ago, right? You wait till now, that don't make even sense. So that don't make no sense, and double jeopardy applies in this case because of the fact that you're trying to frame this man with this mess and set him up with someone. This woman knew she was a prostitute. Isaac, how old is that? I'm not understanding that. I was that child. I don't even know what she's trying to say. And then another comment was, okay, arrested the girls too. They was in for the money. That's prostitution. Selling themselves, that's a crime. If they ever been with Kelly, how we know the girls been with him? It's no evidence or proof. Show us, because this whole thing is just lies. These girls just want money and fame. I bet they write a book off this to get rich. I bet you are Kelly innocent. Child, y'all should have proofread this stuff. Other comments called plaintiff a devil and demon. 2001, question mark, question mark, question mark. GTFOH. We know what that means. Get the F out of here. But he was charged in 2002 and beat the case in 2008. Why not come out then? Question mark, question mark, question mark. Them devils really got it out for Kels. This is BS for real. And then another commenter said, 2001, this is bogus as F. I hope all these demons go straight to hell. I'm convinced this ish got something to do with his catalog, period. Leave him alone, devils. And then these women controlled by Lucifer. Several commenters criticized plaintiff's parents and asked for them to be criminally charged, as they should be. Please, man, at each show, R. Kelly had his own dancer, so please don't spread lies. There was no victim. Do you have special laws for parents to be accountable to all their children? If no, you really don't believe in children, period. Okay, guys, I actually stopped working on this video like 5 days ago. I'm picking back up where I left off. So we're under the section that says several commenters criticized plaintiff's parents and asked for them to be criminally charged. And so the next one goes on to say, so where was this girl's parents that let her go to a grown man room alone? Someone else said, when parents going to be charged? Who lets their teenage daughter go to a R. Kelly concert? Hashtag make it make sense. Most concerningly, some commenters seem to believe they have identified plaintiff incorrectly. They have that in parentheses. Accuse her of not actually being a minor at the time of the offense. This is a circus. The woman was 21 to 22. She's 40 now, and it's on social media. Shaking my head. She celebrated her 40th on IG, shaking my head. And I think this is when they were saying that it was the Addie Prada. I don't have the name in front of me, but I think her name was Addie Prada, because remember, and she was a friend of Lisa Van Allen's, and people were saying that she was also Beverly from the other court cases. But they're saying that is not who that is. And remember when the Eastern District of New York case was going on, when they said Addie, and I was like, well, wait a minute, because one of the bad acts witnesses, her name was Addie. And so I was like, okay, is this the same person? Like, what is going on? But it was a different Addie, and now they're saying that it isn't Addie at all in this document. Then it goes on to another comment that says, no, she wasn't. She was 21. Twitter has exposed her lying ass. Someone else wrote, she wasn't a minor. And then someone else said she was 21. Defendant has been publicly accused and sued by other victims of sexual misconduct. When publicly identified, defendant's victims have endured an incredible amount of harassment, threats, and retaliation. 3 men, all connected to defendant, have been federally charged for harassing, intimidating, threatening, or corruptly influenced known victims for defendant. Richard R. Lyne Jr. has been charged with attempting to corruptly persuade the testimony of an alleged victim by offering her $500,000 to be quiet. Don Russell harassed and intimidated a different alleged victim after she filed a civil lawsuit against defendant. Russell threatened to publicly reveal sexually explicit photographs of her and her sexual history if she did not withdraw her lawsuit. Michael Williams set fire to an SUV leased by the father of one defendant's family. The father of one of defendant's victims while it was parked outside the residence where the victim was staying. Now let's talk about this before we go any further. So we know Richard R. Lyne, he said that he was acting on his own, that Mr. Kelly didn't direct him to try and bribe Ariel, although they did get him to be a bad eyewitness in the Eastern District of New York, where he sat there and talked about how some woman came from under a boxing ring and he had to have sex with her. I thought that story was funny. Then we have Don Russell, who still hasn't gone to trial yet. And, he was accused of threatening Faith Rogers, but so far they haven't been able to make that solid connection that Don was working under the direction of Mr. Kelly. And Don himself has says he was working under his own direction. And then Michael Williams, we know, said that he was not working with Mr. Kelly. And in fact, we know that Michael Williams set fire to not Ariel's car, but the father's car. And, there's suspected that he and Michael Williams' cousin Cash Jones were having an affair, and that he was actually going after Angelo Clary on behalf of Cash that had nothing to do with Mr. Kelly. So then the document goes on to talk about the argument, and they list legal standard. In the complaint, the title of the action shall include the names of all the parties. A party may be identified by initials or pseudonym only where authorized by law or court order. And then they give the Minnesota law that states this, and then it says that it was amended to include the last sentence, thereby allowing in certain cases for a party to be identified by initials or pseudonym. Advised committee comment to 2008 amendment. Although actions must normally be brought to the name of the real party in interest, in certain limited circumstances, the court may allow a party to proceed anonymously. In cases involving exceptional circumstances, the party seeking to proceed by pseudonym or initials must obtain leave of court to do so, and that relief is governed by the court's discretion. State courts have routinely permitted plaintiffs in cases involving assault to proceed by pseudonym, and then they give some cases to support that, and I'm not reading all these. And then they cite refusing to create an exception to the pre-2018 version of Rule 10.01, which required that the names of the parties be used in the complaint, and finding that even if the exception existed, the district court did not abuse its discretion after considering federal balancing tests. And then federal courts have held that Federal Rule of Civil Suits P10A, which generally requires that the title of the complaint name all the parties, creates a strong presumption in favor of parties proceeding in their own names, but the rule is not absolute. Plaintiff B versus Francis, and then they name a whole bunch of cases. I'm not going to read that. Did not prohibit pseudonymous. I don't even know. They just make it up. Pseudonymous. I don't know where they're coming up with that name, but anyway, pleading outright, and it's like they mixed pseudonym and anonymous and created a word, and I'm sure it is a real word since this is a lawyer presenting this document. Pleading outright and outlining a non-exhaustive list of 10 factors courts should consider when determining whether the plaintiff's interest in anonymity outweighs both the public interest in disclosure and any prejudice to the defendant. Federal courts allow plaintiffs to proceed pseudonymously in cases involving intensely personal matters. Doe versus University of St. Thomas. And that case stated, that was one case, and they move into another case that was Doe versus North Homes Incorporated, which stated holding a plaintiff challenging his suspicion from a college for misconduct could proceed pseudonymously because the matters involved very private sexual acts, whether consensual or not, between two young college students, and it is difficult to imagine any resolution of this case without further exploration or truly intimate matters. And then another case holding the plaintiff had a substantial interest in maintaining her privacy as a childhood victim of assault. Despite the plaintiff being an adult at the time the case was filed, and evidence that she publicly posted on Facebook about the case. Federal courts also permit plaintiffs to proceed pseudonymously when there is evidence that the party may face retaliation should their identity be disclosed. See Doe versus Neverson, which was a case heard in the 11th Circuit in 2020. Finding the district court too easily discounted evidence that Ms. Doe would be subject to threats and harassments if she were required to proceed under her real name after viewing 8 threatening or harassing comments on a website post about the lawsuit made by fans of the defendant, who was a well-known singer and songwriter. And that was University of Thomas. Then they state some line for allowing a plaintiff to proceed pseudonymously after considering, among other facts, the public identification would expose plaintiff to a risk of retaliatory harm. 2. Plaintiff should be allowed to proceed by pseudonym. Exceptional circumstances warrant plaintiff proceeding as Jane Doe in the present case. Specifically, the case involves facts that are highly sensitive and or a personal nature, and there is evidence indicating that public identification of plaintiff would expose her and her family to potential harassment and retaliation. A. The case involves intensely personal matters. As alleged in the complaint, defendant abused the plaintiff when she was younger. Requiring plaintiff to identify herself publicly would subject her and her family to significant shame, fear, and embarrassment. Further, due to the intense media attention on the case, if plaintiff is not permitted to proceed pseudonymously, her identity and the facts alleged in the complaint will be disseminated nationwide by the media, as it should be. The highly sensitive and personal nature of this case weigh in support of allowing plaintiff to proceed pseudonymously. B. Plaintiff would face a high risk of retaliation if publicly identified. There is substantial evidence that plaintiff would face significant harassment and retaliation if she is not permitted to proceed pseudonymously. Posting publicly under news stories about defendant Kelly's related criminal case, commenters attacked plaintiff and her family ruthlessly. They accused her of lying, called her a demon, and demanded her parents be criminally charged. Some commenters claimed to have identified her through social media, indicating the maelstrom of online abuse she would personally be subjected to if her identity is revealed. The threats of retaliation other victims of defendants have endured is further evidence of the danger plaintiff would face if she is not permitted to proceed by pseudonym. 3 individuals have been federally charged for their threatening, harassing, and coercive actions against other women who have accused defendant of misconduct. In short, plaintiff sustained permanent, debilitating psychological trauma and emotional distress because of defendant's actions. If plaintiff request to proceed pseudonymously is denied, she would be forced to choose between pursuing justice and redress for the substantial harm defendant has inflicted on her and maintaining her privacy and avoiding unwanted public attention, harassment, and retaliation. Conclusion: plaintiff's interest in anonymity outweighs both the public interest in disclosure of her identity and her prejudice to defendant. The court should exercise its discretion under Minnesota rules of P10.01 and allow plaintiff to proceed by pseudonym, and should put in place a protective order to ensure that any identification of plaintiff to which defendant or his counsel may be entitled is maintained as strictly confidential and or attorney's eyes only. Child, they don't even want Ariel to know who she is. How you gonna sue somebody and don't want them to know who you are? These chicks are crazy. Okay, anyway, y'all, there's still a whole bunch of more documents here. So then she filed an amendment on June 28, 2021. And let's see what this says. Introduction: the court should grant plaintiff motion to amend complaint to allege punitive damages against defendant because the record establishes a painfully clear prima facie case that defendant abused plaintiff. So child, she amending again. She can't make up her mind what she want to say. Oh, come on here. So it says factual and procedural background. Plaintiff alleges in the complaint that defendant, okay, so we done read this all over the place. Defendant was criminally charged in Hennepin County with 2 counts of prostitution. What? Oh, okay. Criminally charged with 2 counts of prosecution with an individual under 18, but at least 16, relating to the conduct underlying plaintiff's civil claims. A warrant was issued, the criminal proceeding on September 12, 2019. Oh gosh. Wait, hold on a second. I'm having trouble with my scroll. I don't want to open these documents, so I'm reading it in a really small pane. And so it says factual and procedural background. Okay. Oh, I already read that. Okay, in particular, the complaint alleges the following factual details. Plaintiff encountered defendant at City Center in downtown Minneapolis. So they're going over, what they claim to be the facts about him giving her the phone number, her going to the hotel, taking $200 to dance, that she was 17. At some point during the incident, defendant told her he would put her name on the list, and this we've already read, so let's fast forward here. It says on February 23rd, 2021, defendant was personally served the summons and complaint in this matter by the Cook County, Illinois Sheriff's Office. The case was filed on March 10, 2021. Defendant has failed to serve any pleading or motion. Defendant has never appeared in the action. The complaint has not previously been amended. How is he supposed to appear when he is locked up? Dumbasses. Argument. Legal standard. A plaintiff may not seek punitive damages in the original complaint. After filing suit, a plaintiff may move to amend the pleadings to claim punitive damages at the hearing in the motion if the court finds prima facie evidence in support of the motion. The court shall grant the moving party permission to amend the pleadings to claim punitive damages. If the trial court finds that the motion reasonably allows a conclusion that clear and convincing evidence will establish the defendant acted with deliberate indifference, the trial court must allow the amendment. See Swalon versus Shimano Industry Corporation. And that was a case that was heard in 1990. Substantially, a plaintiff may recover punitive damages where clear and convincing evidence shows the defendant acted with deliberate disregard for the rights of safety of others. Such deliberate disregard exists where the defendant has knowledge of facts intentionally. Such deliberation disregard exists when the defendant has knowledge of facts or intentionally disregards facts that create a high probability of injury to the rights or safety of others, and deliberately proceeds to act with conscious disregard, intentional disregard, or indifference to the same. Let's see. B. Plaintiff should be granted leave to amend the complaint to claim punitive damages. It is well established under Minnesota law that a physical assault is a sufficient factual predicate for an award or punitive damages. And then they cite some cases. The evidence as a whole furnishes no basis for sustaining a finding that defendant had any occasion or justification for striking plaintiff in self-defense, and the evidence herein is such that a jury could reasonably find that defendant's attack upon plaintiff was made with such wantonness and maliciousness as to show a reckless disregard of a plaintiff's rights. The rule applies in the context of assaults with equal, if not greater, force. Where was the assault? And that, guys, they were quoting cases that they're trying to support their motion to seek punitive damages. That they're not talking about this case. So procedurally, avertments in a pleading to which a responsive pleading is required, other than those as to amount of damage, are admitted when not denied in the responsive pleading. Here, there is a strong and undisputed prima facie case that defendant acted with deliberate disregard for plaintiff's rights and safety by intentionally and sexually abusing her by failing to respond to the complaint. Come on, things, scroll down. By failing to respond to the complaint, defendant has admitted the allegations in therein. A claim for punitive damages is therefore warranted in this action. Conclusion. Based on the foregoing considerations, plaintiff is respectfully request the court grant her motion to amend the complaint to allege punitive damages against defendant. So, child, they saying because he didn't respond that he is admitting that he is guilty of her allegations. Okay, so then this was filed. Come on. So here's something that was filed on February 14th of this year. So memorandum in support of default judgment. Plaintiff respectfully requests the court enter a default judgment against defendant Robert Sylvester Kelly in the matter pursuant to Minnesota rules, of civil procedures 55.01 and Minnesota General Rules of Practice 117.02. As set forth herein, plaintiff seeks a monetary judgment against defendant for her compensatory damages and for punitive damages arising out of defendant's assault and abuse of her when she was whatever age she claims she was. Procedural background. On February 23, 2021, defendant was personally served the original summons and complaint in the matter by the Cook County, Illinois Sheriff's Office. And then they have a document showing that he was served. The case was filed on March 10, 2021. On September 2nd, 2021, the court entered an order granting plaintiff's motion to amend the complaint to allege punitive damages. The amended complaint was filed on September 7, 2021, and it was served by U.S. mail on defendant on September 8, 2021. In support of plaintiff's motion to amend, plaintiff submitted for the court's consideration her affidavit dated July 22, 2021, describing the 2001 incident involving defendant upon which her claims are based. Notice of the February 24, 2022 default hearing and remote hearing instructions were served on defendant by U.S. mail on January 4, 2022. To date, defendant has failed to plead or otherwise defend in this action. Statement pursuant to the SCRA. Pursuant to the Service Members of Civil Relief Act, undersigned counsel performed a military service search concerning defendant on November 30th, 2021, though through the online federal database available. The document generated appears to indicate defendant is not in military service. So I guess you have to prove that the person ain't overseas fighting for the country while you're trying to serve them with a summons. Standard for default judgment. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend within the time allowed by the Minnesota Rules of Civil Procedure or statute, and that fact is made to appear by affidavit, judgment by default shall be entered against the party, and where the action is for the recovery of money only, as is this case here, because she's a gold digger, the court shall ascertain by a reference or otherwise the amount to which the plaintiff is entitled and order judgment thereof. See Minnesota Rules of Civil Procedures 55.01, 55.01b. Plaintiff's injuries and compensatory damages. The record in this matter, especially the amended complaint and the July 22nd, 2021 affidavit of plaintiff, contains undisputed allegations and clear and convincing evidence. I don't know what the clear and convincing evidence was. Have we presented some clear and have I read anything about some clear and convincing evidence? That defendant assaulted and abused plaintiff when plaintiff was of certain age, and that in doing so, defendant intentionally or recklessly disregarded the rights and safety of plaintiff. Plaintiff sustained permanent psychological injuries and emotional distress as a direct result of defendant's conduct. Plaintiff attended a psychological consultation with Dr. Alfred Kara Youssef, MD, on October 28, 2018, in connection with the continuation of Social Security disability benefits. Because the government wondering, is she still crazy? We need to find out. So plaintiff has received Social Security disability benefits arising out of mental health conditions since she was approximately 19 years old. Kara Youssef's report notes plaintiff was, quote, "arred by a stranger when she was a teenager, and plaintiff continued to suffer nightmares and flashbacks as a result." Oh, she a good old actress too. Let's see. The R referenced in this report was the abuse committed by defendant in 2001 when plaintiff was 17 years old. Now listen, y'all. First of all, there was no R that took place. And did she not willfully go up there? Did she not willfully take them $200? Did she not willfully dance? And did she not willfully take her butt to that concert after the fact? So where was the psychological damage when she was singing in that audience to, Bump and Grind or whatever songs was out at that time? Like, where was the mental damage at that part? Anyway, child. So plaintiff receives mental health counseling and treatment through Nystrom and Associates, where she has been a patient since at least 2012. So it sounds like to me that she got some other stuff going on. Scamming the government for SSI benefits seems to be one of them. And then maybe something did happen to her, and then she saying, well, okay, I can collect some money now, and I have a better chance of accusing R. Kelly than I do of accusing the person that actually did something to me. So the record from an appointment plaintiff attended on October 30th, 2020 with therapist Gilbert Gung evidences plaintiff's ongoing psychological symptoms, emotional distress, and disabilities. The report notes and details symptoms consistent with anxiety disorder, panic attacks, and PTSD. The report also identifies plaintiff's report of assault she suffered as an adolescent as a developmental incident, which was a contributing cause of her current PTSD and other psychological symptoms. The first assault at 15, noted on page 4 of the report. Did I not just say something must have happened to her? Okay. Lord Jesus. So she was assaulted at 15, noted on page 4 of the report, and the assault and abuse in adolescence referenced on page 2 of the report referred to the abuse committed by defendant in 2001 when plaintiff was 17. So how did she know that all of this damage that she had suffered wasn't from the 15 attack? And then maybe that's what made her loose and willing to be going to a grown man's hotel room to be dancing for $200 and some concert tickets. So it seems like she's suing the wrong person. It seems like she needs to be suing whoever messed with her when she was younger. So if it cannot be disputed that defendant's abuse of plaintiff when she was younger was the primary cause and or substantial contributing cause of plaintiff's severe and permanent psychological injuries and emotional distress, an award of $2 million would constitute adequate compensation for plaintiff's injury. Oh my Lord, punitive damages. The conduct of defendant was criminal, premeditated, and in deliberate disregard for the rights and safety of plaintiff. Abuse is a sufficient factual predicate for an award of punitive damages under Minnesota law. The purpose of punitive damages is to both punish and deter according to the gravity of the act, giving rise to a punitive damage award, but an award should not exceed the level necessary, this don't make no sense, to properly punish and deter. The punitive damages statute instructs that an award of punitive damages be measured by those factors which justify or justly bear upon the purpose of punitive damages. Minnesota statute section 549.20 subdivision 3. The following statutory considerations warrant a substantial punitive damages award against defendant: the seriousness of defendant's misconduct, the duration and repeated occurrences of similar misconduct over many years and involving many victims, of which the court can and should take judicial notice, the duration of defendant's concealment of and avoidance of responsibility for his misconduct, defendant's awareness of his misconduct, and defendant's use of his position of power as a celebrity and his employment of agents to carry out the misconduct. I'm sorry, at any point did it say he asked her age and she told him that she was 17? I can't remember reading that. Or did he just assume that since she was doing grown woman things, that therefore she was a grown woman? You guys let me know. Concerning the financial resources of defendant, the federal government represented to United States District Court Judge Ann M. Donnelly in connection with the recent criminal prosecution of defendant in the Eastern District of New York that defendant continues to receive hundreds of thousands of dollars in connection with royalties he is owed for his music. The government's investigation has revealed that earlier this year, 2019, the defendant redirected those royalties to a bank account of childhood friend, and that's where they were talking about Keith was getting the money so that he could pay the bills and whatnot. While specific details regarding defendant's financial resources are currently not known, the available information indicates defendant earns considerable and ongoing income. If y'all don't stop streaming that man's music and giving these heifers opportunities with these get-rich-quick schemes, I don't know what else to tell you, but I'm just thinking that nobody who supports R. Kelly should be streaming his music at this point, knowing that these women, just stealing his money, and the courts are allowing it. These factors all weigh in favor of a substantial seven-figure award of punitive damages sufficient to meet the related goals of punishments and deterrences. Conclusion. For the foregoing reasons, plaintiff respectfully requests the court enter an order awarding her $2 million in compensatory damages, $2 million in punitive damages, and pre-judgment and post-judgment interest, and further directing that judgment be entered against defendant in the amount of $4 million. Respectfully submitted, Mya Blake and Associates. It just never ends. It just never ends. Okay, so the next document, notice of judicial assignment, general civil block cases, Jane Doe versus Robert Sylvester Kelly, date case filed March 10, 2021. All future papers must include the above file number, name of assigned judge, attorney identification number, and must otherwise conform to formal requirements or they will be returned. The case is assigned to Judge Kristen Sigmund. The writing is really small, and I told you guys I'm reading this in a preview. You spell it Kristen, Kristin, Sigismund, Siegesmund. If you receive this notice and have obtained an attorney, notify hereinafter. So basically, they assign the case to a judge. And they're asking, I guess, Mr. Kelly to file who his attorneys are. And then this is from July 26, 2021. Notice of continued motion hearing to Mr. Kelly, MDC. So this is something they sent to him at the MDC. Please take notice that plaintiff through undersigned counsel will bring before the Honorable Kristen Sigismund, Hennepin County District Court for continued hearing. Plaintiffs previously filed and served motion. And then that hearing was for September 1st, 2021 at 1:30 p.m. And it says such motion shall be heard, shall be heard remotely pursuant to instructions provided. Then on April 1st, 2022, was another notice of motion hearing that was sent to him at the MDC, stating that there was a hearing on February 24th, 2022 at 8:30 a motion for default judgment pursuant to Minnesota ruling. So we know he said he didn't get that. And then notice of motion and motion. This says, notice of motion. Please take notice that plaintiff through undersigned counsel will bring before the Honorable Kristen Sigismund District Court for hearing the instant motion on July 19, 2021 at 1:30 p.m. Such motion shall be heard remotely. And then the motion. Oh, come on. And so plaintiff respectfully moves the court to leave to amend the complaint to allege a claim for punitive damages against defendant. The motion is based on the deliberate disregard for the rights and safety of plaintiff. Plaintiff's motion is supported by the memorandum. So that's something else they're trying to get in. Okay. September 2nd, 2021. She granted the motion. It says the matter came before her on the plaintiff's motion to amend her complaint to include count seeking punitive damages. The hearing was first held on July 19, 2021. Attorneys for the plaintiff, no one appeared on behalf of the defendant. At that hearing, the court requested a supplemental affidavit from the plaintiff in support of her motion and continued the hearing on September 1st, 2021. The plaintiff filed her affidavit on July 22nd, 2021. Okay, so that was basically, they said that they could collect the damages. And then on May 6th, 2021, what was this? This was an order. And this was basically them saying that she could go ahead and file this case under a pseudonym. Let me get back to where I was at. Okay, and then we have some more complaints where they kept re-amending. March 10th, 2021, March 10th, 2021, June 28th, September 7th. I don't know why. Amended complaint and jury demand. So it's like they're going to milk her. If she does get an award in this case, they are going to milk her out of all this money because they just keep filing the same thing over and over. And I'm not seeing any changes in all these filings. And they're probably charging her like $2,500 every time they file a document. And let's see, what is this? This is from, let's see. What is this? You are responsible for designating all non-public documents you file with the court. I don't know what this is. Non-public documents. Cover sheet for non-public. Okay, so this is where they file something under seal, and then they're just posting the cover sheets, letting the public know that something was filed. And then this is from April 5th, 2021, a memorandum. Memorandum in support of plaintiff. You see how they're just filing the same documents? So, because we've already seen all these documents that they're filing, but they're all being filed multiple times. And that's also, I'm trying to get to the part, there's just so much stuff in here. Let's see. And that's where they assigned I'm not sure why. That's when they served him notice. So we already read this. Already read this. Already read that. Okay. I'm trying to get down, you guys, to the part where they had these. Okay, here it is. And actually, I'm going to read it, but then I'm also going to create a video of it and then drop it in my video. So this is social media. They have all these social media postings. So there was a story from Fox News 9, and then I guess they allowed people to comment. And it says, singer was charged with misconduct dating back to an incident in 2001. And so this is Minnesota's Fox News. And then there were 3 comments. Someone named Layla Hairston said, showing R. Kelly some love, and then she has the heart emoji, stay strong and praying. Jai Norman said, I don't believe he did it. Charmaine Jordan said, oh my God, leave the man alone. You are going to kill him. I want music. Help these victims to find a job and a life and stop victimizing R. Kelly. You all need to listen to this man's music. He is a lover, not a fighter. Then there is a drawing, a court drawing, and this is from CBS New York. It says Kelly faces new crime charges in Minnesota, and it's a drawing of him before a magistrate. And looks like Doug Anton because the person got their hair in a ponytail. Okay, so I think that was when he was being arraigned in New York. So then we have Zelda Williams says, there's always a Minnesota connection. The thinky emoji, okay. And then Lady Kai, who lets their teenage daughter go to an R. Kelly concert? Make it make sense. SS2, Gloria Allred, no press conference, smells fishy. Legacy Freedom wrote, these women controlled by Lucifer. Jai Norman wrote again, I will always support Kelly 100%. And then there were 2 replies under that, one by somebody, the Chimmy. I support his music, but not his bullshit. He needs to be locked up. And then SS2 replied to Jay Norman, it's simply, these are stories, not facts, allegations. If this man did all of this 20 years ago, why didn't they press charges then? Team Kales all the way. Don't be a sheep. Think for yourself. And it goes on and on and on. Like I said, I'm not going to go through all these, but it was just news. Like they were showing screenshots of the actual news story, like the image that you get, when you see my videos pop up, or you see anything on YouTube or in the media, they'll have a photo. So they'll have the photo, and then they'll post all the comments. Then they're sharing all the comments under those. And let's see. So when they did this video, it says raw. Kelly charged with underage prostitution in 2001. So this was a video of the press conference, and this story appeared under Care 11. There were 173 comments under that post, and so I'll read this one. It says, Antonio Pope wrote, this is disgusting at this point. From this announcement that was made, I would be trying to track down the alleged phone number and the hotel records to prove any kind of validity to this victim's accusations. The new allegations supposedly happened 18 years ago. This is beyond ridiculous at this point. At this rate, any woman in the state can accuse him of something and say it happened decades ago. Honesty is the real victim. It is being abused. It's non-existent at this point. Women are greedy. Women and greed are making names for themselves at the expense of this man. And then people commented under that saying, the Minority Report stated statute of limitations is 20 years starting after the age of 18. And then Antonio Pope replied, will the law recognize a statute or bend it to make it work in its favor? No law is black and white. Sonia Briggs wrote, Antonio Pope, I'm sure that part is already handled. Laugh out loud. And then someone named Hyman wrote, if he wasn't a P word, women in greed wouldn't make a name for themselves. And then Benjamin Coleman wrote, you know the feds have the information right. And Reese C wrote, she danced and got paid. Oh, I think I read that one already. Get out of here. She was mad because he changed his number 18 years ago. So anyway, I'm going to make a video of this. I'm scrolling through it because it's 22 pages of comments that they're trying to show. Oh, here's a long one. What does this say? And this was by Janice Figures. She wrote, I'm just looking at this. I just want to say something. 2001, whatever happened then, she, the woman, lied about her age to try to even get to the point to be around the man. He was acquitted in 2008. That was in 2001. So how did that work? You've appointed the woman, lied about her age. I want, child, she ain't writing in good English. I can't read that. There's no way that woman is 17 or 18 trying to accept money. Does she accept money for whatever she thought herself trying to do? Child, y'all be writing so crazy. Anyway, child. Let's see. So Kelly's fans was out there. They was fighting. They were yeah. All these girls waited this long for, then question mark. Yeah, it was interesting. Lord have mercy. Let me see. Here's another document. And now they're just quoting like news stories about the Arline and Williams and Don Russell cases. Then they posted affidavits from the Arline case. The affidavit from Don Russell's case. The affidavit from Michael Williams' case. Then we got a cover, Exhibit A. Let's see. What's your exhibit? Nothing. Let's see. Wait, let me open this one up so I can see what it is saying. Exhibit A. Oh, I think this is the report. Oh, this is the report where, remember I said that they had to go and file with the military to see if he was in active duty. That's what that was. That's a document that, see, these are repeat documents again. Proposed order of judgment. We've already read this. Let's see. I think we already read this. Yep. And then here is a summons that was dated from March 10th to Mr. Kelly. It says, you are being sued. The plaintiff has started a lawsuit against you. The plaintiff's complaint against you is attached to the summons. Do not throw these papers away. They are official papers that affect your rights. You must respond to the lawsuit, even though it may not yet be filed with the court and there may be no court file number on the summons. You must comply within 21 days. And then they talk about how he can give a written response and send it to her attorney's office. You must respond to each claim. The answer is your written response to the plaintiff's complaint. In your answer, you must state whether you agree or disagree with each paragraph of the complaint. If you believe the plaintiff should not be given everything asked for in the complaint, you must say So in your answer, number 4, you will lose your case if you do not send a written response to the complaint to the person who signed this summons. If you do not answer within 21 days, you will lose the case. You will not get to tell your side of the story, and the court may decide against you and award the plaintiff everything asked for in the complaint. If you do not want to contest the claim stated in the complaint, you do not need to respond. A default judgment can then be entered against you for the relief requested in the complaint. 5, legal assistance. You may wish to get legal help from a lawyer. If you do not have a lawyer, the court administrator may have information about places where you can get legal assistance. Even if you cannot get legal help, you must still provide a written answer to protect your rights, or you may lose this case. 6, alternative dispute solution. The parties may agree to or be ordered to participate in an alternative dispute resolution process under Rule 114 of the Minnesota General Rules of Practices. You must still send your written response to the complaint, even if you expect to use alternative means of resolving the dispute. So, that's where we are. And then, as I stated long ago at the beginning of this video, that someone, I'm thinking it's one of the jailhouse attorneys, did respond to, once they tried to enter the default motion, did respond and say that he had no knowledge of this lawsuit, that he never received any paperwork, and that the attorneys from this chick in Minnesota then withdrew the motion for default. And Jennifer Bonjean stated on Twitter, when she was asked about the case, did state that they are trying to find an attorney in Minnesota who would be willing to take on this case and help him, get it resolved. And so if you know any lawyers in Minnesota, that handle civil cases of this nature, who may be able to help Mr. Kelly, can you please reach out to them and see if they would be willing to speak with him about this case? Because we just cannot let these women keep winning, because at this point everybody is going to be filing lawsuits. So we already have Heather Williams, who's been awarded a $4 million default judgment. Then we have Faith Rogers, I think, withdrew her case in New York, but has signed on with a new case involving Lisa Van Allen and somebody else. And then now we have this case. But if they keep awarding these default judgments, then these women are just going to keep filing these lawsuits, keep filing lawsuits, keep filing lawsuits. So guys, that's it for me. Go ahead, leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.